All right, what's up, y'all? Hopefully, this was substantially better than the beginning of the last one. I hope that it was. So, if you thought that was dope, that's our boy Stevie Irwin, just crushing the game always. The guy is a master. I gave him zero time to put that together, and he put together what I consider to be a masterpiece. So, thank you, Stevie, for that. You're an amazing human being, and you're forever my graphics guy. So without further ado, I want to introduce somebody who's substantially better looking, substantially more brilliant than I am. My partner in life, my partner in law, and my co-host on this show, moving forward forever and ever, Ali Mata.
Hey,
What up, girl?
why do I look so big?
I mean, you're close.
I don't know. It didn't look like that before.
All right, so we'll say hi to the people. Don't worry about that. Say hi.
Everybody.
All right. So, all right, guys, thank you for joining us. This is what I consider to be our first real live stream. Hopefully, it looks like, from what I'm seeing, the picture's way better. The sound should be good. And we've got some documents prepared. I did the homework. I put the work in. So hopefully this will be a much more pleasant experience than the first one. And, I just want to go through a few ground rules. I, of course, got my homies in here. I've got Jay and Shannon are in here, and my boys. I don't know if Dan's in here, but I know Steve's definitely in here. Dan may be in here. Dan and Steve really spent a huge amount of time with me on Saturday, trying to get my head out of my ass and to learn how to actually stream competently. So I thank those guys so much for taking their time on a Saturday when they could be chilling, because those guys have real jobs that they work every day, all week. So they gave me their valuable time over the weekend, and I'm forever thankful for them. All right. And as you can hear in the background, my daughter is off stage putting dishes in the sink. We are a family. We, at this point, do not have like a dedicated studio where Allison is going to be able to sit in a quiet space. We're trying to keep it quiet. We'll get a dedicated space, but for right now, just know that we've got kids and dog, and it's going to be loud. So it's not going to be overly loud, but it'll be, for me, annoyingly loud. Hopefully it's not too bad for y'all. Most of you guys know Scout, so she's out there. Our 17-year-old is going to come in at some point. Hopefully Allison texted her and told her, try to keep it down when you come in. And also we're working to get Allie's podcast mic connected to her up here so that she'll be able to sound phenomenal like she does on the podcast. So again, ground rules, just be cool in the thread, in the comments. We're real big on everybody being civil, everybody being polite. We can have disagreements. And look, in this stream, on this channel, there are bound to be things that we all don't agree on. Okay. And that's good. We don't want to all agree on everything. It makes for a very, very boring life. And I've always said, like, you can't solve problems if everyone is always agreeing on everything. You need pushback on things to get to solutions. So, just be cool. If you're ugly, if you're in here trolling, you're going to get bounced. We don't want to bounce people. We want everyone in here to have a good time. Allie and I want to educate you on some stuff, and there's going to be things that you may not agree with, and that is okay. I want to state that unequivocally. When we're going through documents, it's us trying to impart what we know about the law to y'all so that you can understand it as well. We're going to take questions, obviously. And I just found out that we, in the blink of an eye, got monetized by YouTube. I just found out right before I came on this live, so I don't know if I set it up where you guys can do all the stuff that you do. If you can and you will, that would be amazing. We'd be forever grateful. So what we want to do is kind of get rolling now, and I'm going to have the mods looking for good questions as we're plowing along. As you guys know, tonight what we're doing is we're going to be focusing on, and trust me, Allie's going to be talking plenty. I'm not going to be. She'll be talking a lot, but for like kind of the intro, I just kind of want to lay some ground rules. So tonight, obviously, we're talking about the Delphi docs. I think we've pretty much covered as much as I want to cover with respect to the memo that was filed. We're obviously going to be touching on that because it's kind of the thing. But there's been filings that have occurred since then. Namely, the state responded, which I don't really think we got to because I was so irritated the other night with the condition of that particular stream. I wasn't feeling it. I'm in a much better mood tonight because I can tell that we look good and we sound good, which is important. You know, we want you guys to come on. We want you to subscribe, smash that subscribe button. We want you to interact. We want you to enjoy it. We want it to be something that's worth your time because we know you all are giving us your time, and we are beyond grateful that you're doing that. And when I say that, I truly, truly mean it. So tonight, what we're going to do, we are going to go through first the state's response. Okay, so that is their second objection. Okay, is that do you want to go through that first, Al?
I mean, it's up to you. I
Like kind of in order of what I thought that we should put up. I thought that we should kind of go through that and explain kind of what's going on with that. So, and just so everybody has a clear understanding, remember again, we're talking the way that it worked is there was a motion to suppress was filed, okay, by the defense, and they are trying to suppress the search of Richard Allen's home that was before the affidavit for the arrest was filed or was granted by the judge, and then they got him under arrest. So you have the search of his house that took place. They then went to the house. They completed the search. They got the 40 caliber Sig Sauer. They got a bunch of clothes. They got a blue jacket. They got jeans, boots, tons of stuff in that search. And Allie had wanted me to put that affidavit up, but like I just it wasn't something that I had put in. And I think that we kind of went over what they got in that search. But that is all of this that is going on right now is about that particular motion to suppress the search. It's not about attacking the arrest. If they win this, meaning the defense, if the judge grants this motion to suppress, I fully expect that they will next attack the affidavit and they're going to try to quash the arrest warrant. Okay, they're going to say, okay, all of that is out of the arrest warrant now. Now you're left with what is left, which again, it's going to also have the effect of pulling, because if they win that particular motion, this motion here, when it gets to the hearing, and we're going to explain the process of how it gets to a Franks hearing tonight. But if they win that and the judge says, okay, I find that Tony Liggett lied and I'm pulling out the lies, I'm pulling them out of the probable cause affidavit that was attached to the warrant for search warrant, or the search warrant for the house. And from that point forward, all you have left is what you have left, right? So if that's pulled out, that means that it will be pulled out of the affidavit that was attached to the arrest warrant as well. So they'll be left with those things pulled out, everything that was suppressed pulled out, and you're basically going to be left with what I feel is basically mere presence. And Allison, how is mere presence? Like, do they like that in the law?
Well, no, they do not like mere presence in the law. So I mean, I guess it depends how much of the timeline is actually challenged or at issue, because as we discussed before, and as we'll get into further into this, when in the state's most recent filings, they included another affidavit that included all of this same information. That's their way of telling the world, we didn't lie, everything's true, because guess what? We're saying it again. So, I mean, I guess it depends on whether all of that really would come out.
Right. All right. So okay. So Allie, I'm gonna pop up the second objection. Okay. So just so you all know, the state's response came out probably about 10 days, it seemed, after the. Okay. So here we have this, and Al, can you even come close to reading that thing?
No, but what I can do is open it up like on my other screen and no one can tell that that's when I'm
Okay.
actually looking at it.
Okay, good. All right. So while you're doing that, and I'm going to have you do the heavy lifting on
So
what this was.
this is the defense's supplemental motion for a Frank's hearing. Is that where you wanted to start, or you wanted to
No,
start?
I already screwed up. All right. Let me find the right document. All right. Bear with me. There's still going to be hiccups, kids. There's no question about that. So let me see. I've got slides, motion, quest for substitute. Okay. All righty. Let's add this one. There we go. Look at that. It was almost competent. It was almost like I was almost competent there. All right. So this is the state's second objection to the defendant's motion to suppress. All right. So this is what they filed in response to the motion to suppress and the memo. All right. So why don't you tell the folks what you saw on this?
Well, primarily they're speaking to the standard and the law and not really getting into any factual disputes per se. And Bob, you found one paragraph particularly interesting.
I did, and that was paragraph 7. So it's my favorite paragraph by far, and essentially what that paragraph says is that oh no, wait, this isn't even that right paragraph. Let's
Well,
see. I take it back. It is. So paragraph 7, which I thought was the most telling, and this paragraph, I think, directly rebuts the people that have, number one, who have not read the memo and who have dismissed it offhand, having not read it based on reading a newspaper article or whatever you've decided to base your opinion on, without having read the full thing. And I get it. It's long. It's 136 pages. I can understand why you may not want to spend your day reading that thing. So, but what they said here is that, once again, while the memorandum is colorful, dramatic, and highly unprofessional, this is the part that that stuck with me in that sentence. It is not completely true. So you can only take that one way. And you can take that as it's an acknowledgement by the state that there are truths in that memorandum. There's no other way to read that. And if anybody wants to debate me on that out there, I'm here for it. I'm happy to debate, because when you get to the heart of that memo, when you strip away the Odinism stuff, they could have kept out 90 pages of that and just put in a basis of what Odinism is, and then stuck in the evidence that we've got 4 guys, 3 of which have direct connections unequivocally to Odinism, that you can find it on their Facebook pages. They're not hiding it all. You've got the guy Elvis who literally confessed to 2 of his sisters at being in the crime scene. I mean, there are things in this memo that, and again, I need everybody to understand that everything that's listed as evidence in this particular memorandum of law came from one of 3 sources. Okay. It came from the state and their police reports that they tendered to the defense. It came from affidavits, sworn affidavits, and it came from depositions of law enforcement officers. That's where everything came from. This wasn't 2 lawyers sitting there with their staff cooking up stuff up until 2 a.m. for 3 weeks and then filing this. This was a defense team going through every stitch of mountains and mountains of discovery and finding these documents relating to Odinism and these guys that were just randomly stuck They call it the needle in the haystack, and it's accurate. And Allison and I have experienced it. You know, when the state gives you discovery, they're not necessarily trying to do you any favors. They're certainly not going to give it to you in an organized fashion, because that's our job. All they have to do is turn it over. Typically, they'll bait stamp it so that they know what the count is in terms of the number of documents that they're turning over, and that's it. They're not going to be giving us a table of contents. Oh, here's all the guys that we interviewed that talked about being at the scene of the crime and spitting on one of the girls. Oh, here's the guy who none of that happened. So these guys had to dig through everything that they've gotten, and they didn't get the stuff with these guys until September. All right, so they then freaked out when they found this evidence in there, as Allison and I would have as well. Our minds would have exploded. I would have been screaming, or she would have been screaming, "Get in there and look at it." And, I mean, from that point forward, they start to develop their defense theory. And I've been very clear about this, that unequivocally, they definitely used a Frank's memo to really kind of be the beard for getting what their theory of the defense is. And this is without question what they're going to be presenting at trial, should it make it there. This is going to be their defense. They're going to be putting these three guys under the microscope, four guys really, but Holder allegedly has an alibi. I mean, he has one per police reports. He claims to have clocked in and clocked out from work, which would have put him at work at the time that they suspect that the killings took place. But that's another thing that we're going to get to a little bit tonight. We really don't know what the time of death of the girls is or was. We just don't know it. We know that they didn't show up when Libby's dad came to pick them up. And beyond that, we really don't know. They have not been able to put a time of death. This could have happened under cover of darkness. I mean, it's hard to know, because that search that night, remember, this is in February in Indiana with no daylight savings time. It is pitch black by 5 p.m. So the search, if you know anything about this case, did not last long the night the girls went missing. So the bottom line is the ME is going to do the best that they can. The medical examiner is going to do the best that they can to try to establish a time of death. And typically that's going to be from clues like, is the body in rigor or rigor mortis? Has the lividity started? Those are the things that they look at. And, but it's not a perfect science. It's just one of those things where they can kind of take the clues of what they're seeing and try to estimate. They can look at the contents of the stomach and try to see if food has been eaten and how far along the digestive tract it is and things like that. But in terms of being able to pinpoint and say, we know that it happened at 3 p.m. or 3:30 in the afternoon, they can't really say it. And I challenge anybody to say, and again, they may have evidence that we don't know, but in terms of what was exposed through this memo, it does not seem to me as if they can pinpoint an actual time of death. It seems like it's a lot of supposition at this point. So, all right. So
let me just say that generally what the state is basically relying on is they're saying that the information that they included in the warrant was really all they needed to include in the warrant. None of that information, like they focused on the fact that Richard Allen put himself on the bridge wearing the similar clothes during the time frame that when they interviewed Richard and Kathy, they indicated that, again, that he was on the trail the day that they went missing. He also said he was wearing blue jeans and a blue or black Carhartt with a hood, and that he stated he did own guns and that guns were in the home, and that he still had guns and knives in the home along with a blue Carhartt. They go on to say the investigators believed a firearm was involved in the abduction and murder of Abigail Williams and Liberty Germain because an unspent 40 caliber because an unspent 40 caliber round was found between the bodies of the girls, and Then they say, and this is what I find very telling, that investigators believed a knife was used in the murders. So in the same sense that they gave a reason why in the paragraph above when you're dealing with the gun, that is a paragraph that typically they would indicate why, such as, the stabbings on the bodies, or such as there were wood carvings or whatever we're calling these runes or objects that were, at least according to the defense's position on the evidence presented by the state to them, that there was a sharp object used to make these runes or alter the branches or whatever the case may be. And I find that very telling that they don't put any reason why knives were in there. And that might be an area where the defense can sort of get in there and say, assuming what they're saying is true, that is, that the reason they believed a knife was used was because it was clear that a sharp object had been used to make these runes or to, stage the scene to look ritualistic, whatever the case may be, that may have played, into the judge's position on probable cause. But essentially they're saying, he was there, he's wearing the clothes similar to the person that was on the bridge. A lot of people saw this guy on the bridge, and, we think that that's enough. So,
I mean, let me ask you, Allie, is that the response that you would have expected from the state?
Yes.
Me too. Like I there was no part of me that thought that they were ever going to get baited into like trying to rebut the Odinism stuff. I thought that they would completely ignore it. I thought that they would base it on the warrant, the affidavit for the warrant, what they had informationally speaking inside that affidavit, and the law. And that's exactly what they did. It was 8 pages long. It was concise. They argued that, look, I mean, essentially, because and you had mentioned to me that, they doubled down. They essentially doubled down. Not only did they backtrack and try to look really, they did not backtrack. They doubled down on what Liggett said in the affidavit. So, I mean,
they included all of those same statements about the witnesses, the muddy and the bloody, like nothing changed. And then they added additional information that they found out. So, for example, in the first affidavit for warrant, unless I'm missing something, I just pulled it up to double check. There's no reference to this. We believe we heard the word gun on the video. But then when you get to this new affidavit, and I think it's contained in some other affidavits that came after the fact, it says the video recovered from victim's two's phone shows victim 1 walking southeast on the high bridge while a male wearing a dark jacket and jeans walks behind her. As a male subject approaches victim 1 and victim 2, one of the victims mentions, quote, gun. Near the end of the video, a male is seen and heard telling the girls, quote, guys, down the hill. The girls then begin to proceed down the hill and the video ends. And then they talk about how they put together this still frame from it. So they're definitely, by filing this and including all this information, saying, like I said earlier, everything we said was correct the first time, and guess what? We're saying it again.
Right. So, which, I mean, I guess that has to be their position, right? I mean, they're certainly at this juncture not going to make admissions that Liggett lied. You know what I mean? They're like, I did not expect them to come and say, got us. I mean, the fact of the matter is that there's going to be police reports. They're going to put these 2 women on the stand, and I'm assuming they're going to subpoena them if they're not, like ready, willing, and able to come in on their own accord. They will subpoena them, and they're going to say, look, did you make a police report? And just so you guys know, police reports cannot come into evidence. They are considered to be hearsay. They don't fall under the business record exception of the hearsay rule. They can be used to refresh recollection, It can be used to impeach, but you can't introduce a police report into evidence. So that means that if they have the girls on the stand, the women on the stand, they say, okay, do you remember making a police report? And they say, kind of, or yes, or no. If they don't, then what do? What does an attorney do if you have a witness on the stand, Allison, and they say, I can't recall?
They'll refresh the recollection with the statement. Or, if it's a pretrial motion, usually the rules of evidence are relaxed anyway. So, they'll just get in the statement and discuss it from that point of view.
Right. So, I mean, I fully anticipate at this hearing that they are going to unequivocally be able to show that Tony Liggett flat out lied.
But you do have to think of it. Let's assume that the only thing in here are the omissions, because like we said, they've put it in another affidavit, sworn document since then, and listed it as their probable cause to support another search warrant. If the only thing that is really of issue for Franks is whether these omissions, where they don't necessarily have to say we've got all these other suspects, but omissions of facts about, the crime scene itself, the way that it looked.
About a certain individual named Elvis that made admissions to two of his sisters, claiming that he was at the scene when the girls were killed and that he spit on one of the girls and that his DNA, like something like that's a pretty big omission. Would you agree?
Yeah. If the judge says that they were required to include that information.
Well, let me ask you, I mean, under what circumstance would they not have to include something? I mean, it's clearly exculpatory as to Richard Allen, right? So, I mean, are they obligated? And if they know that there's something exculpatory that exists out there in terms of a police report from an individual who they then took the sister who called law enforcement and said, okay, look, my brother just told me that he was there when the girls were killed. They brought her in and they did a polygraph on her and she was telling the truth. Now, does that mean that he was telling the truth to her?
No,
not necessarily.
Right.
But it certainly means that he said that to her and she was telling them the truth, that she was told that by her brother. Does that mean that that was necessarily true? That's a different issue. But, I mean, do you think that there's a world that exists where that kind of omission can fly, where the judge is going to say, well, yeah, I mean, to me.
Well, they're arguing in there, and I don't know if you mentioned this yet, about they did their supplemental motion. They're arguing that Allen offered up dozens of pages of police reports from various law enforcement officers, all which focus on individuals other than himself that could have committed these crimes. Then they go into the depositions and the transcripts, and both written and recorded statements of witnesses on and near the trail that day in question who articulated facts entirely inconsistent with those offered up by Sheriff Liggett in his affidavit supporting the search warrant. And again, the prosecutor just offered up those same facts in support of a new subpoena, not a search warrant, but a subpoena. And then, so, like the state doesn't put anything, the defense doesn't put anything in their new motion. And I started to research the law in, where are we?
What do you
Indiana.
mean?
Right.
Yeah.
About, what level of exculpatory information, is necessary. And you would expect them to, to kind of give some cases that support this. And the case law that they are relying on is sort of showing that it's a relatively low threshold that's needed to advance to the actual hearing, that it's something less than, preponderance of the evidence, and just more than just straight supposition. But, they use this example of where the police officers relied on, a reliable source that indicated that, wait, sorry, I've got to find it now. So there was one where they say that they relied on a reliable source to say that he was in his apartment, in this other defendant's apartment, and purchased marijuana while he was inside. They put reasons why the person was found to be reliable. And then while asking for a Frank's motion, what the evidence that they offered up to meet the preliminary threshold was that he said that he was somewhere else, and he put affidavits from family members that he was in another location, and that the unnamed informant claimed to have, while the unknown informant claimed to have a rendezvous at his house. And they're saying, like, despite the fact that they were sort of self-serving, the court found in that case that the threshold requirements to offer up a Frank's, to have a hearing was met. And in another case, they talked about something dealing with that they relied on, they being the police, relied on a phone number. Here it goes. So they had a specific informant placed a sports wager with the defendant through a specified phone number registered in the defendant's name. The officer swore that he confirmed the phone number with the phone company, and the phone number was in fact in the defendant's name. So in that case, the defendant filed a request for a Frank's hearing and put forth an affidavit saying that that phone number was not registered in his name, and he attached the phone bill showing that the number was not registered to the defendant. And there they found enough to go to a hearing. But what they don't do is apply, put forth anything that would be specific here. Like in this case, there was an omission of exculpatory information, or in this case, there was all this other evidence that pointed to a third party that, was enough to get a hearing. They don't do any of that, which leads me to think they couldn't find any law that spoke to that issue. And again, I think I think that they have put evidence forward to challenge the timeline, and that the judge could find that that is enough to warrant a Frank's hearing. I'm just saying, at the end of the day, if that's the issue she wants to focus on at a Frank's hearing, the fact that the state's doubling down on this seems to indicate that they think it's all accurate.
Right. And just so y'all know what Allison's doing right now. So typically in a responsive pleading, and when we get to what the defense filed today, it's what was lacking in their original memorandum, because typically they call it a memorandum of law, meaning that you include the law, case law, precedent. They kind of forgot about that when
they were
filed
talking about in their motion, in their actual motion.
Well, no, they didn't. They
didn't do it in the law in this either, but they filed.
Well, I mean, they had some case law in what they filed today. Or
right.
Are you talking about the state here?
No, I was sorry. I was talking about the defense filed a supplemental motion, and that included the law.
Well, that's what I just said.
Yeah. Oh, I thought we were talking about the memo.
What I'm saying in the memo, they did not include any law. I'm explaining to people, because you have to remember, babe, we have people that aren't lawyers in this group. They don't know. Yeah. Well, so like wow. They, in terms of what they're doing in this. So when the Allison was like actually telling you about the cases that they incorporated in their response, that is how the state was addressing issues, using case law, using precedent to say, hey, judge, this is why you rule our way, because this, and this. But what Allison's saying that they didn't do is that they didn't make the comparison to the case at the bar, meaning this case. So they're citing case law, but they're not applying that law to the facts in this case to show that that's why it's on point, that it's precedent that works for the judge to be able to hang her hat on. So that's what Allie was doing there.
They seem to be hoping that the judge just sees the direct connection. And to me, the direct connection with the cases they're using, with the fact patterns they're relying on to tell the judge what their burden is, it speaks more to their whole, that the eyewitnesses said something inconsistent with what Liggett said. That seems to be what it's more directed at, which is sort of like the point you've made before, that most of the direct, like Frank's evidence stuff, came very later in their memorandum.
Right. So, well, and look, I mean, I think what's clear, and I try to explain to people that lawyers are not going to put their professional lives on the line and lie in a pleading and just make things up. Like, so when they're saying that one of the witnesses, one of the two eyewitnesses that they're really attacking, that she said, look, he was wearing a tan jacket, and then Liggett changes it to blue. That's just a flat out lie. That's not interpretation. When one of them, we have the issue that this very well could be a completely different set of girls, because Alan in his own statement says that he sees 3 girls. Now in the affidavit that came from the state side, they said there were 4 girls, and they all gave different descriptions. And it that goes to how incredibly unreliable eyewitness testimony can be. When
Right,
you
but
have 4,
enough to get probable cause, unless he's, I don't know as to that victim if they really believed that she said tan and they wrote blue, because there's one of these, I'm sorry, witnesses that they said was just a dark jacket. Again, in their newest statement in support of the subpoena, doesn't say anything about her saying it was a tan jacket there either.
yeah,
So
but what I'm saying is the police reports do.
I know, but so we're telling the people right now, like a lawyer's not going to put their license on the line, but one of these 2 lawyers did it. Either the state just did it by again putting it
Doubling
into
down.
another, pleading, or the defense was wrong. One of the 2 of them was clearly wrong, considering that the state did this again, wrote it again.
Right. Okay. So, Al, read that question. So, but how many crazy, outlandish tips? So this goes back to what they can exclude. What do you think?
There, I mean,
Like
there were tips that that this guy, the father of one of the girls' boyfriends, had this stuff on his website and was some posted on Facebook or whatever the case may be, and they should look at them, But again, the correlation that they're making was an informant said he was there on this date and time. However, they interviewed the family members, said, no, the defendant was with me at that date and time. Again, it's a very low threshold is what they're trying to establish. You only need to challenge it a little bit, but that was a direct challenge to a direct, statement. Again, same thing with a reliable source that he called him on a telephone number registered to him. And then the officer says, I checked that number. It's registered to this defendant. Then the defendant puts in an affidavit that says, that's not my number. And here's the phone bill for, here's something for that number showing it's not mine, which they, like I said before, didn't really, connect those dots. So the tip in this case is a third party that they seriously believe and should have been further pursued. Is that something they needed to offer up in the affidavit? And the defense didn't put any law that speaks to that issue.
Right. So not in the memorandum, but
right.
so as far as, so the next thing I'm going to put up there for you is kind of a partner question to this. And it's relating to the particular individual that.
You can take down that document.
Oh, okay.
Yeah.
All right. So why was it bugging you? Did that?
Well, I just thought we were talking about other documents, and now that people can see us better.
Oh yeah. Well, I mean,
you can see your handsome face more.
I can see your beauty. I can see your big, beautiful face. All right. So this is kind of a partner question to that. So Elvis, the kid or the young man that made the statement, that made the inculpatory statement, allegedly. But again, I'm saying allegedly, but it's in a police report that he went up, and I think that it was to Murphy. Murphy is one of the 3 cops that continued to investigate the Odinism angle. And we're going to get to this statement by Click. Right. We're going to get to that. Not quite yet, because after the defense's motion came out, Click made a statement. They read it in on the Murder Sheet podcast. I think Court TV read it out. He had made statements kind of distancing himself a little bit from at least what the defense was putting out there. I don't know that he backtracked completely,
Right,
but
but this Murphy guy, like you were saying, he was where when you go back through and parse the original memo, he's the one where a lot of the Odinism stuff, and I'm going to do that for the people once we get to that, say like,
okay.
this was his statement, and then go back and say, well, what did the affidavit, what did the memo really attribute to Click?
Right.
And how both can exist in the same world.
Right. So that,
Oh,
which is
so can
important.
Elvis really be charged? Sorry. So obviously they're not going to charge anybody else right now, but let's just assume Richard Allen was not charged. He could be charged even though he has a low IQ, but depending on how low, it could form the basis of a defense. And it definitely would be mitigation at sentencing. But if it, prevented him from understanding what he was doing and what, assuming that this was a story like he was one person with a group of others and he didn't really understand what they were, about to do or what was happening, it could be a defense. But yeah, he surely could be charged regardless.
Right. Or if they go to trial and Richard Allen is acquitted. Okay.
Right. Or even in this case, if they go to trial against Richard Allen and the defense wants to put on this either statement by Elvis or call Elvis, obviously the state can challenge the statement, the credibility of the statement, by putting in the evidence of his IQ.
Right. And look, I get the question, but I don't think that the fact that he has a low IQ means that he can't tell the truth. As a matter of fact, I would argue it's the opposite, that he's less inclined to lie because of his low IQ. I think that people with higher IQs are probably more apt at lying because it requires considerable amount of more thinking in terms of being able to lie and being able to remember the lies. Like it's a whole thing. To me, a low IQ would be indicative of somebody probably telling the truth when, again, and I had a conversation with Brett of the prosecutors when as soon as I got to CrimeCon, I cornered him because I've been trying to get him to debate me on this thing.
Sticks might be just be sticks thing.
Well, it just he's of the mindset that this thing is hot garbage. Basically that it's a horror, a horror novel, and with a little bit of Frank's hearing crammed in there.
Right, but
let me get to what we were saying before you jump in. In his position, in his comeback to me, in terms of this kid having a low IQ, which the defense put in the memorandum. It's not as if they were trying to hide the fact that this kid has a low IQ, because I think that they probably think along the same lines that I do, which is that I think that the kid's more prone to be telling the truth because of the low IQ, not that he's making something up because of the low IQ. So Brett's pushback was, okay, well, then you have to say the same thing about Brendan Dassey. So when Brendan Dassey, but here's the difference, and this is my reply to Brett, since we haven't been able to debate this out. The difference is this kid voluntarily went up to a cop and made a statement to a cop. This isn't a kid who is sitting in an interrogation being fed information. They're two entirely different circumstances. So to me, I reject that notion completely. I'm sorry, but I do. When you have a kid who's going to walk up and just say something out of the blue, oh, hey, by the way, if you guys find my spit on one of the girls, but I can explain it, am I still in trouble? I mean, like that sounds like a question that a kid with a really low IQ would ask. Because if you have a high IQ, you're not asking a cop, if I spit on one of the victims, but I can explain why and how it happened, am I still going to be in trouble? That's not something with a high IQ that you're going to do typically. So I think that all kind of like falls into that. But the bigger thing is the fact that Brendan Dassey was being interrogated. That's the primary difference. This kid was not being interrogated at all. Like he was wherever they were talking to him, he was out. He walked back to the police car and asked the cop this question. And it was Murphy. Murphy was the cop. So, all right. I want to throw this up because we're kind of into it. So in this is the exhibits that were attached. okay, by the defense. So for everybody that's out there saying, oh, this thing's garbage, this is, this tells you what they included. Now, obviously, things that were very sensitive in terms of pictures, all that stuff is sealed, but it gives you an idea of exactly what they put in. Okay. And these are the receipts, as we like to call them, in terms of what they had attached to that memorandum for the judge to review, to say, okay, we're not just coming out from like left field with nothing behind us, because that's part of a Franks hearing. You can't come in, you have to substantiate, right?
Absolutely.
Okay. So, which is going to get me to really the defense's response of their supplemental motion today that dropped. That is where they're saying, look, this is how the process works, Judge, and this is the law that supports the process. So again, so just so everybody understands, there has to be a preliminary showing, okay, that what the defense is saying in terms of the lies, that there's enough there, that they have enough evidence, that there's proof of the lies that have taken place in order to get to a Franks hearing. So the first thing that's going to happen here is they're going to go in and they're going to argue that aspect of it. And these are the things that they're going to be bringing to the judge and saying, look, this is what we're saying happened. This is the evidence that we have of it. And if the judge finds it sufficient, she's going to order that there's a Franks hearing. So when you're looking at it, I mean, and you can kind of like, what do you glean in terms of like, let me ask you, because you do a bulk of the motion work and you did through the course of my career and our career together, in terms of importance from a defense attorney's perspective, are you more inclined to put what you consider to be a banging fact early, or are you putting a banging fact late, thinking that it'll be the last thing that's stuck in their head? You want it to be the first thing they see or the last thing they see, they being the judge?
I think you want it to be the first thing they see and then to reference it again in the conclusion.
Right. Which you're very good at referencing things again.
Wow.
Zing.
Yeah.
I love you, babe. Allie, like in terms of her motion work, I'm just going to put it as she's extremely thorough.
And sometimes repetitive.
A little,
He was getting
you just want to make sure that the judge gets your point. I mean, it's like, do you understand what I'm saying to you? So it's like, but wow. So what we have here with the exhibits, you look at it, and they start with the affidavit from Click and the letter from Click. And remember that this letter from Click to McLeland is basically alleged, and we haven't seen it. I can only go by what the defense is saying in their memo. It's that basically when the PCA for Richard Allen dropped, that Click was extremely concerned with the fact that they had placed him under arrest. And he's like, all right, look, I just need to talk to y'all because obviously you must have found something else out, because what I'm reading in that thing ain't it. So he sends this letter and they have a meeting with him and they don't address any of it. So that takes place, and you've got the situation where the defense finds out. This thing gets turned over, like eventually to them in discovery. Again, this was tendered in discovery. The state has to tender that stuff. So, and as you kind of plow through, you can see that, they have all the crime scene photos.
Or they have an affidavit of Todd Click. That's very important.
Exactly. And again, you guys, I'm sure 98% of you know an affidavit is a sworn statement. It's the exact same as if somebody is sitting on the stand and has been sworn in, except it's in paper form. All right. So you've got all the confidential crime scene photos that obviously we were not privy to.
And autopsy photos.
And the autopsy photos. You've got the confidential, some of what they consider to be evidence of the ritualistic nature of the crime scene with the F on the tree. You've got an interesting thing where there's a photo of a yellow rope tied to a tree. So I mean, because we've always wondered, was one of the girls somehow bound while, because for one guy to do this, there's got to be some control over the second victim, right? In terms of
At
being
some
able
point,
to physically do it. So, I mean, there can be, we can jump to a conclusion there that rope may be tied
right. And
somehow
don't
to the
forget the
crime.
DNA documentation showing that the blood that made the F on the tree and, the blood on the ruin or the sticks belonged to one of the victims.
Right. And it's here's the thing, and I have this on pretty good authority, and I think that anybody that follows the case, they did not take any of the sticks or the bark from the tree into evidence, which is stunning. Like I cannot understand a world in which any crime scene tech would not take everything that was touching the girls, on top of the girls, near the girls, anything that's painted in Abby's blood on a tree. They took swabs. They took swabs of the sticks of the blood to find out whose blood it was, but they didn't take the sticks. I'll never understand it. I'll never understand it. And I mean, because there's a difference between just a bundle of sticks being placed on the girls in order to try to hide the fact that there's bodies there. And what I'm envisioning, at least if we're to believe the description that the defense gave, this is not piles of sticks used to try to cover the girls' bodies up. It's not what I'm envisioning is going on. I think that when we see these photographs, if we ever do, I mean, I'm going to be in the courtroom when this thing's at trial. So I'm going to be able to walk up after every day in the hearing and look at the photographs, because they're probably not going to televise them on tree. Like, I'm putting eyes on these things because I want to see them, but it's one of those things where it's inexplicable to me in what world that they didn't think that was relevant evidence.
Right. So they basically, without having to go through all of this, I mean, like Bob,
go through the yellow ones, I mean.
Oh, you can then.
Yeah, I mean,
I'm looking at I'm looking at it bigger. I don't have them yellow. So go ahead.
Okay, so like Ryan Boucher or Boucher, Bobby Boucher, the water boy. So he is the guy that basically ran into Holder's Facebook page and was like, man, this guy's disturbing to me. He was able to, he got screen grabs of certain things that were then deleted soon thereafter from Holder's Facebook. Those disappeared, but the defense tracked this guy down in Georgia, got an affidavit from him, and also got the screen grabs that he was able to get of Brad Holder's Facebook account. You've got the video of Elvis, the interview, which, I mean, the judge is going to look at all this. She's going to hear all of it. You've got tons and tons of side-by-sides of their Facebook, their socials, going here. And like Holder just had some really disturbing stuff. Does that make him a killer? No, it doesn't. But does it make him a suspect potentially? I think so. I think that he deserves to be looked at. And like I say it every time I'm on a stream, this is not Allison and I sitting here with a Richard Allen fan club. What this is us saying that all of us, the only thing we want is justice for Abby and Libby in this case. And I have seen enough other evidence that exists in the police reports where I have serious concerns that they have the right man in custody, period. No one is getting me off of that. I don't necessarily I'm not sitting here saying that he is innocent, because I don't know, because there's tons more that we don't know in terms of what they've collected against Richard Allen, if there is any. I mean, we know, at least according to the defense, that they have not collected. They found nothing on his any of the electronic devices, nothing on his phone, on his computers. If you look at the property evidence log from the search of his house, they took this guy didn't throw phones out. He had everything. And beyond throwing the device itself out, they're always going to be able to get the records. They'll be able to see when calls were made. They're not going to be as obviously as inclusive as what were you going to say?
I was going to say, so you've got like Jamie Hutchison. sorry, I'm probably butchering your name, but she asks, what does any of this have to do with Frank's, which is valid to an extent. What do you see as far as the evidence list that speaks directly to, like the actual untruths that were told? As opposed to
Yeah, I think that's on, I think that was on slide 2. It's basically where they have, so they've got Betsy Blair, her sketch of the vehicle. They got Sarah Carbaugh's interview. Okay, like that's where, so they got Betsy Blair's interview. So they have 2 interviews of both the women. So those are germane to obviously the Franks hearing. You're also going to have Richard Allen's interview, the later one, not the one where he made the original statement. And we're going to be able to compare and contrast timelines. But in terms of direct evidence, I'm assuming, and now obviously I have not been able to watch these videos, but when you have Sarah Carbaugh's interview from 6/7 of 2017, and then Betsy Blair's interview from more recently, but still a few years back on 3/7 of 2019, we have to assume that those are going to be evidence as to the things that Liggett lied about. In addition, if you look through 103, 104, 105, 106, they then include the affidavit of search warrant. So I'm assuming that those that precede 108, so 103 through 107 will be direct, like they put those in order so that they can show this is what they said, okay, in their reports. This is the sketch of what the vehicles look like. She's talking about a Mercury, like an old muscle car, and he's turning it into a Ford Focus. And then you've got the affidavit for the search warrant. So they're using those to build up to that affidavit of the search warrant. Then, of course, you've got Betsy Blair's sketch of the vehicle. You've got the photo of the Ford Focus, similar to the one owned by Richard Allen in 2017. And then you've got the video. So I think that those specifically are going to the Franks hearing. And then you've got A through F down there, the list of the depositions.
Right. And as Bob made reference to earlier as to Sarah, is it Carbaugh?
Yeah.
Carbaugh. The defense claims, citing to her recorded statement that what in fact she told the police was that she saw a man wearing a tan jacket and his clothes were muddy, so that she never said a blue coat and she never said bloody clothes. But again, the state, after this memorandum was filed, 2 days later, was it the next day? Which was it? Let me see. I'll pull the date right here because I got it up.
No, they didn't file this response until
no, but they filed a motion for a subpoena on February 25th, 2023, and this memorandum accusing them of lying in the last affidavit was filed.
I'm pulling that up for you.
9/18/2023.
So this is that request for subpoena that you're talking about.
Yeah, I'm looking at it. So if you,
I pulled it up for our viewers to look at it.
Oh,
it's nice that you're looking at it, but our viewers might want to look at it too. It's not all about you, babe. So this is exactly what you're talking about. So this is where they double down. So this is again, as Allison was saying, you can see the file date was September 25th, 2023. So, and as you look, this is basically, they cut and pasted. If you look at page 2, 3, 4, this is the affidavit. So they cut and paste the affidavit, from the original warrant, and they double down on it. They're not backtracking on anything. They're using it as a basis for a subpoena because they're trying to get, like you said, they're trying to get Richard Allen's medical records. So
and they again said the same thing. She advised he was wearing a blue colored jacket and blue jeans and was muddy and bloody. So
right.
Like someone needs to be seriously disciplined. Either the prosecutor who filed this after being cited to the document and the portion of the interview where she does not say that, filing again, or the state for not thoroughly, the defense for not thoroughly reviewing all of the discovery and, making these assertions without having reviewed all the evidence. I mean, one of the two things that is happening here.
Yeah, for sure. And just so people understand that they're like, I think there's a misconception out there that lawyers can just go ahead and lie without any repercussions. And that is not the case.
Wait, defense attorneys, they can't lie whenever they want. I thought that was like a class in law school.
Oh, you're no, that's defense attorneys went to liar class. Pick stupid juries and go to law and learn how to lie. That's what defense attorneys, according to Wendy Murphy. So as far as what happens, if people are wondering, is that a complaint gets filed. Now in Illinois, they call it the ARDC, the Attorney Registration Disciplinary Committee. I have no clue what they call it in Indiana, but they have the exact same,
Attorney discipline something. It's going to be.
Yeah, it's the same concept. It doesn't really matter what the name is. So as far as if this shakes out after this hearing, and Gull is like, and it could be Gull. Like if Gull's like, number one, you filed this thing not under seal when you should have, and you knew better. Putting this out for public consumption, it's completely transparent that you were simply just trying to get your narrative out to the public the same way that the state does. But beyond that, to the heart of the motion, you clearly didn't do your research and you fired this thing out. That is who would turn them in. That's who would file.
Right, or on the flip side, they should be that outraged with the state if they filed the same.
100%. Definitely. I'm not picking on the defense here.
No, I know you're not. I'm just saying, I would hope if it was the state who was being disingenuous and doubling down with incorrect information or misleading information, that there should be some repercussions from that.
Yeah, and Allison's right, though. It's like we've been doing this for a long time. I mean, typically we take the beatings in court. I mean, the reality of kind of the judicial system in this country is that the pipeline to, the bench is typically the prosecutor's office. I mean, I think if you were to statistically look at, on average, what the pipeline in terms of who ends up on the bench, it's astronomically higher prosecutors than it is defense bar attorneys end up on the bench. I mean, that is kind of the pipeline. Now, I'm not suggesting that there's blatant bias there because it's former prosecutors. And Allison and I have seen it firsthand where defense attorneys that finally make it onto the bench and we're like, woohoo, they turn out to be much worse.
Overcompensate.
Yeah, they're overcompensating and they're much worse than the prosecutors that are on the bench. It's like, it's crazy. It's like there's, so it's one of those things that's just a reality of the system. And I mean,
you've got a question here from Denise, like how can the state use these people? How can the defense use these people's names without getting sued for defamation?
My mods, can like Jay or Shannon, like when you guys, because I'm like having a hard time keeping up with some of the questions. Can you guys throw them up there? I need help with that. Like if you guys see a good question, throw it up.
So Denise asks, how can the defense just use these other guys' names, e.g. Holder, et cetera, without fear of getting sued for defamation? And that would be because the truth is a defense to defamation.
Exactly. So
you can't get sued for telling the truth. And especially in a pleading, there is, whether they needed to put the name in or not, there's really nothing improper with putting the name in.
There's not. It's like
decides it somehow, went to the heart of the gag order, but I don't think that it really should.
No, well, look, and here's the thing. People keep confusing gag orders in a case being sealed. Gag orders relate to not pleadings by attorneys. Pleadings by attorneys can include everything that we think is germane and pertinent, whether it be law, if we're trying to seek.
But the state's still doing it every time they file something.
I understand, but I'm trying to explain to people that they're confusing gag orders in a case being sealed. Gag orders are you can't talk to the media about the substantive parts of the case. All you can talk about is scheduling. You can't talk about anything regarding the case. The media, that's not the same thing as a case being sealed where there's an order, which, by the way, the state just filed again today that they want everything under seal again. So they're like, it was so late in the day that I didn't even get to pull the docket up. I couldn't email the clerk to get the thing. So they want everything under seal. They're two different things completely. One is a gag order relating to the media and being able to talk to the media. The other is that documents are under seal, and sometimes they can close a courtroom, as Allison talked about on, I think it was on one of our podcast episodes, when she was representing R. Kelly's wife in, like a support matter, which, by the way, Allison's the first attorney to ever get that suck bag put in jail for failure to pay. How much was it? Like some astronomical amount of support. What a scumbag. Guy's like a multi-millionaire and he doesn't support.
All right, so switching back, by the way, Jay's texting you because he's unable to post them.
Jay, how do I change that setting, dude? Like you have to be able to
just read the text and we'll figure it out for next time.
Okay. All right, let's see.
Let's move to I sort of started to discuss the supplemental motion. I mean, I did kind of.
Do you want me to pull it up?
If you want, but I think that we, I'm
gonna pull it up. I took the time to
yeah.
I took it it was, I'm old. It was very challenging this is a lot of tech for like an old guy like me. Oh, I made a document appear. It's amazing. All right, so here it is. So this is wrong.
Nope. That's
wrong.
doubling down.
See what I'm saying? See that's
doubling down subpoena.
All right. Okay. So here we go. So this is the document. This is supplemental. So this is what includes. This is the oops. Yeah, I mean, we got a little carried away with our memorandum and we forgot to put the law in there. So here it is. I mean, that's essentially what happened. It's essentially what it is. All right. So what do you think of this document, Al?
And I already kind of spoke on this. This is where I was reading the law from that they were, that they were using, where I was reading about the comparisons they were making where an informant said, this is the phone number I text him through. And then they did the affidavit and where an informant said, I went to his house on this date and time. And the defense put in evidence that the family members had told the police that he was with them during that date and time, and that was enough to get a hearing. So again, this is them they showed that the law, it's a relatively very low threshold. It's like they don't want it to be automatic, but it's not to be very hard to get to a Franks hearing. And they just didn't really apply the law to any of the omissions. Like why leaving out the fact that there were these other suspects was important, and leaving out the fact that there was odinistic aspects to it was important. They didn't do any correlation in the law that speaks to that aspect of it. And that's because, as you said before, the really important stuff here is any omissions or inconsistencies or misleading as to what those eyewitnesses, the timeline, what they said they saw and when they saw it, kind of thing. Well, but I think we should go into this.
Before we do, I want to ask you, I mean, if they get Liggett on the stand, he can only do one of two things. He can either continue to lie, which to me would be insane if he knows these police reports exist, or that these witnesses are going to come on and say, I didn't say that. You literally changed my words. Right?
Well, it's a recorded interview, so they have it. Like you said, you just went through the
I don't know if those are in the recorded interviews or if they're that's one of the, you know what I'm saying? Like there's police reports.
Either a police report says it or it doesn't. So Liggett would have to produce the report that references these, statements. And if so, like you just said, maybe the defense is going to put on a witness who says, that's not what I said, but we didn't see any affidavits from them. So it doesn't appear as though the defense has had a follow-up conversation with those witnesses. It appears the defense is basing it off of the statements that were provided in discovery about what they said in the first place.
Now, that's an awesome point. That's an amazing point. And frankly, a huge point that could be a telling point. The fact that they didn't get affidavits, because if you and I had ran into these kind of reports,
We didn't send
like,
our investigators out to interview them, but
immediately.
they may have told, they may have told the investigators they don't want to talk, or it may have been, under the gun, too many things going on at the same time. They never got around to it, but that seems very unlikely for as diligent as it appears they were being.
Yeah. I mean, but it's interesting. Like, I haven't heard anybody bring up that point, and it's just, evidence of your brilliance. Like that, like the fact that there are not affidavits from these witnesses, to me, can be telling, because like you want a sworn statement, like in a perfect world, or maybe they just agreed to come and testify.
Or maybe it's so clear that the statements don't say that they didn't want to risk going and getting, some other statement from these witnesses, because if what was issued in discovery doesn't say what he said it says, maybe they felt that was enough to get them to their hearing, which is really all they want to get to. They want to just have that public hearing.
Right. So, I mean, and look, so what, all right, what were you going to jump to? Like, what did you want to address?
I was going to jump to the statement made by Click. So I'm sure all of you know, but
don't assume that. There's people that don't know.
These 3 officers who the defense claims, continued to investigate and led to all these other suspects who were Odinists. So Click made a statement, or provided a statement to Murder Sheet that was read on their podcast, which said this. So this is Click's statement. So first of all, he said, like, there's a gag order. I'm going to respect that, because he is law enforcement that worked this case at some point. I don't know if he still is or not. I know somebody was former, but so he said, there are 2 things that I would like to clear up immediately. The first part doesn't really matter here. Detective Ferenczi and Detective Murphy were not Rushville cops. Detective Ferenczi was a detective from the Terre Haute, what is it?
Terre Haute, Indiana.
Haute, which is
Allie's from Pennsylvania, so forgive her. She's not a Midwestern girl. She's an East Coast girl, so don't be too tough on her with her butchery of all things Midwest.
Police department was assigned to the FBI Joint Terrorism Task Force. Detective Murphy was an Indiana State Police detective that was also assigned to the FBI Joint Terrorism Task Force. So the FBI was associated with this investigation until at least July of 2021. Secondly, and this is the important part, no one in law enforcement believes Abby and Libby were killed in a ritual sacrifice. That is the defense twisting facts for sensationalism. You can quote me on those 2 items. Now, what I did as a result of that is went back to the memorandum that they filed and said, what did they attribute to Click? And how do these 2 things make sense in the world? And what it appears to me is the focus is on a ritual sacrifice. But it is clear, based on, and there's from his affidavit and his police reports as quoted in the defense memorandum, that he believed these 3 guys who are Odinists committed this offense.
So what you're saying is that they're not mutually exclusive. They, like, Click can believe that this wasn't a ritual.
Wasn't a sacrifice, a ritual sacrifice.
What? Come on, girl. Same shit. Same difference.
Well, no, because
semantics.
No. To me, if he would have said it wasn't a ritualistic killing, then I'd be like, well, what? So you don't think those were runes, and you don't think that was an F, and like that would bring in, all of these other things. So I want to go over for the people what was in there. But what were you going to say before I do that?
Well, they weren't. They're not. He can think that it wasn't related to Odinism per se, but can still think that these guys are the people that killed them.
Right, that Odinists killed her and
Or-
either wasn't
or
related.
white supremacists using Odinism as like, oh, I think it's kind of a neat religion and Vikings are cool as shit. And I kind of feel like a Viking. I think I was really born a Viking and
Right.
I
So,
identify as a Viking, right? I mean, like,
so he that doesn't say whether he still believes that Abby's boyfriend's father was involved because somebody's mother or family member was, in an relationship, mixed race relationship, or whatever the case may be. So now let me go to the memorandum. And so what they say about Click here is, so firstly,
sneeze.
bless
Excuse me.
you.
How you?
Bless you. All right, it's all highlighted in green, so I've got to find the green highlights without going past it. So I'm going to make this smaller. Okay. So, all right, stop.
All right. Well, Allison's looking. Make sure y'all are smashing. I don't know where that came from. Smashing the like button. Please subscribe. We're going to give you awesome content all the time. We both kind of know our shit, so we're hope that you're going to be digging in with us because we're going to do this all the time. And I'm dropping a little hint here. We'll be live again Wednesday. Subject matter unknown at this point, but Thursday we got something big planned, and I've already talked to Jay about it. Because like it's running up against his show, which we don't like to do. And I'm talking about the shaming of Jay. If y'all don't know who I'm talking about,
Yes, Shannon and Jay, both amazing.
yes, we love them deeply. They're homies.
Okay.
All right, what do you got?
All right. So first thing is
Smash and like and subscribe. Sorry.
After reading Richard Allen's probable cause affidavit, Click became concerned that the information contained in Richard Allen's affidavit pointing the finger at Richard Allen was far less compelling than the totality of the information that Detective Ferenczi, Detective Murphy, and Officer Click had accumulated during the Rushville portion of the investigation. The information that Murphy, Ferenczi, and Click had gathered during that investigation connected men who practiced Odinism in or near Delphi with another group of men who lived in Rushville, and then connected both groups of men to the murders. And then in that footnote, they say, find the attached affidavit of Todd Click. So based on that, that must be what Todd Click said. And that is different than saying that it was a ritualistic sacrifice. It's saying, I connected these men who practiced Odinism to the murders. Right. It goes on, the memo goes on to say, Click was concerned that for some reason, the leadership of the investigation team had failed to share with Prosecutor McClelland the evidence gathered by Click, Ferenczi, and Murphy. Click's concerns led him to seek out a lawyer to assist him in drafting a letter. This letter was then sent to McClelland. And of course, they attach and reference the letter. It goes on to say, Click was determined to ensure his information was consumed by McClelland, that he directed the information directly to McClelland via certified mail letter, stamped received May 1st, 2023. Click's report landed at ground zero at the prosecutor's office. So that's them, establishing that the prosecutor himself, they all knew this stuff. And then they go on to say that there was this 85-page compilation of reports by Click prepared in 2019 that had videos and statements. And here's a direct quote that support the defense's theory of Richard Allen's innocence. So they didn't say the defense's theory of a ritualistic sacrifice. You know what I mean? So I'm basically, and Bob, tell me if this is interesting or helpful at all.
Everything you say is interesting and helpful, just so you know.
I was just going through this trying to say, how can these two statements exist in the world and both be accurate? Meaning the statements in the memorandum and the statement of Click saying no one believes that this was a ritual sacrifice. So the other thing that it goes on to say, that according to the summary of Click's investigation that he attached with his letter, quote, the Behavioral Analysis Unit, the BAU, of the FBI determined that the individuals responsible for the homicides were involved in Nordic beliefs. That is a direct quote.
Right.
So from Click's letter. So again, that's why I'm saying he definitely believed that the people who committed the homicides were involved in Nordic beliefs. It just seems based on his statement, he doesn't believe that it was a ritual sacrifice. And then the footnote for that is the summary that Click wrote out and attached to his letter. And they say under Exhibit 4, Odinists have Nordic beliefs.
I mean, so did you watch when I was on STS? Were you watching that stream where they had the Rick Ross guy?
Yeah. That guy, I don't know what that guy's.
No, I mean, I'm not going to sit here and cast shade on him, but like the one thing that I'll say is he clearly had not read the memo, and I said at the beginning of this stream, and I'm going to say it again.
Sorry, go ahead. Sorry.
Well, I mean, what were you going to say?
No, finish.
No, so I mean, just my thing with anybody that's dismissing this thing without looking at it, you're out of hand. You're not bringing anything to the table. I will not debate people on Twitter, and make sure you follow my Twitter at defense_diaries. I'm super active on there. I'm more active on that thing than anything else by far, which is going to change. I'm going to be more active on this with my wife, who kills the game, as you can see. See that? Allie has a sexy brain. What?
You want me to keep going?
Oh, so yeah, I got, I was like I started thinking about your sexy brain and got me all like off kilter. But like, I just want to point out the fact that you shouldn't be engaging in the conversation about whether or not this document has merit unless you're willing to put in the work and read it for yourself. Because what I'm going to tell you flat out is it has merit. That nothing in here, strip away all the Odinism stuff. Strip it away. There's no well about it. I'm like, no one is convincing me that in the search for justice, in the search for the truth, that this line of investigation should not be more thoroughly investigated, period.
Agreed.
I don't care what anybody says. Anybody that reads those statements and says, I'm good, they're out of their minds, period.
Right.
And it's not
absolutely agree.
I mean, if we want justice for the girls, they have to be investigated. There is enough there that they have to be investigated, period. And when somebody asks a question, I was like, well, when they named them, can they sue for libel? I dream that Brad Holder would sue them for libel, because you know what happens then? They get to depose him, and they get to ask him everything in a deposition. Everything. And if he doesn't want to answer, he'll never do that, because he will explain. Like, any lawyer's gonna say, well, yeah, Brad, come on in, have a seat, buddy. So what's going on? Well, hey, man, you see all this shit online? They're accusing me. I did a funny video where I said, "Oh, this hat fucking pisses you off. Oh, you think because I'm wearing this hat that I fucking murdered somebody?"
Can you play that hat video?
Oh my God, I put it on Twitter. I'm like, this guy's out of his fucking mind. Like, pardon my French, but I'm like that alone. If you don't want to have people suspect you of being a murdering bastard, then maybe don't put that shit on your socials. The day that the thing drops is when he puts that on. Like, I'm assuming it's gone. I'm glad that I screen grabbed it.
Take that memo off, or that motion. Supplemental.
Oh, you're so beautiful. I love when you get big again. All right. So yeah, I mean, look, I'm clear on this thing, man. I am not saying Richard Allen is innocent at this point, because it hasn't gone to trial. They could have evidence. I don't know. But what I do know is that based on what I've seen, that it requires more investigation. I know that there were 3 cops, and Click may be taking a step back.
Well, that's what I'm saying. I don't know that he is, because
to a certain extent.
Well, but this is his affidavit that he provided for the motion. He said, upon directing the letter to Mr. McClelland, I heard nothing from the prosecutor's office or any other members of the Unified Command until I received a phone call on August 23rd and August 25th, which involved brief discussions regarding scheduling. During these phone calls, it was requested that I meet with Trooper Holman during the week of September 4th. I was informed that law enforcement officials intended to sit down with me and discuss with me the reasons why Richard Allen was responsible for the crimes. I was told that he, Jerry Holman, wanted to put my mind at ease. However, during the meeting with Detective Holman and the second detective whose name I'm unfamiliar with, there were no discussions or offerings as to why they believed Richard Allen was guilty of the charged crimes. I believe the interview was an attempt by them to clean up their loose ends, knowing that they had given very little, if any, attention to the investigative efforts of myself, Detective Ferenczi, and Detective Murphy. So again, and there's plenty more examples in here that I've sort of outlined. That's why I think he's saying, I don't think it's a ritualistic sacrifice, but I sure as shit think it's Odinists who committed this offense, right, and that there's no evidence against Richard Allen.
Exactly. So that's all we're trying to say. And like this is going to bear itself out. And again, if they have the wrong man currently sitting in a penitentiary awaiting trial, that's a problem. That's a problem for everybody who gives a shit about this case, for everybody that cares about those two girls and their families getting justice. It's a problem. Because, and I want to try to make your brains explode for 1 minute. And I want to pretend all those people that for whatever reason, and there can only be one reason that you're convinced that Richard Allen is the proper person, and that can only be based on the PCA. It can't be based on anything else because there is nothing else. So that means that you have decided to take full bore and put all your faith in the fact that you believe that the cops and the prosecutors got the right guy based. And remember, I've said this a million times, and I'm going to say it again. At the time the PCA was drafted, they put the strongest evidence they had against Richard Allen in the PCA. They are not holding back smoking gun evidence. They're just not doing it. It's exhausting that I keep having to have that battle on Twitter. It's exhausting to me. Whoever told you that, whether it was Jennifer Coffindaffer, I don't know who it was. It's wrong. That's not way. They are putting their best foot forward because, again, I'm going to just say it one more time. That is the state's first time. Huh?
I'm sure this is not your one last time.
Oh, why are you going to call me out? I'm just an old man who repeats shit.
Listen, it's the state's opportunity to get their narrative out to the world, to the public, that will sit there and fester until trial. That is typically what happens in every single case. It's the state's narrative that gets out. This case is so unusual, and people are so upset because for once the defense got their narrative out there. And you know what it does? Is it does create reasonable doubt in your mind because they're putting out some facts that the state didn't give you. So here's where I want to blow your minds. And the other part is the defense is going to attack those PCAs. They're not going to put hot garbage up there because they know we can get the thing quashed. They're going to put their best foot forward. And again, the investigation is just beginning upon the arrest of the defendant. That's facts. It's not over. People are like, oh, he's under arrest. They're done. No, they're just getting started. What, babe?
So Robert Vineyard asked, please explain what this click stuff has to do with the affidavit being invalid or having been falsified such that it warrants a Frank's hearing. Not to be antagonistic, I want to understand. It sounds like a cop with whatever put out that his peers and superiors prefer a theory other than his. So I just want to touch on this. So there's one thing like that Bob's saying. He's saying how this memorandum speaks to like truth and justice. When we put it in a vacuum specifically for a Frank's hearing, there's a lot of it that we say, might not be on point or super compelling for the purposes of a Franks hearing. What the defense is trying to argue is that this evidence that there were these other people and the evidence about how the crime scene was appeared and the things on it would have made the judge question whether or not now this limited evidence, this guy on a bridge who has no ties to this other world, is there enough probable cause to go searching his house for, a bullet that they might have found in the middle of the, between the kids. So there's kind of two sides of it. One is just truth, justice. Do they have the right person? And this memo is very important and speaks to that, like in all sorts of ways, that more investigation needs to be done, more investigation needed to be done before an arrest. And then it's sort of like adding on to the issues for the Franks hearing, which more directly deal with the timeline omissions, the changing of like the way witnesses said what they saw, tan jacket, black jacket, stuff like that. And the defense is trying to put as many things as they can. And it'll just be a question of whether the judge finds that there was such an exorbitant amount of exculpatory information pointing to somebody else that they were misled by the lack of information on those points in the affidavit, because the judge had no reason to even suspect that there was any sort of, that what the crime scene looked like or what it might involve. And they're hoping that was enough, coupled with the other things, for the judge to say, I might not have found there was probable cause.
Exactly. So,
but again, they didn't put the legal arguments in there to support that aspect of it, which we spoke to earlier.
Right. And I hope you all get what Allie's saying, because that's why it matters. I mean, that's what I was saying in terms of like the fatal flaw with the memo was the fact that they went too far afoot. They could have accomplished that because they had to bring up the onistic aspect. They had to get the judge to that place in her mind that this isn't some kind of shit that we're pulling out of our ass, that it actually exists. And these guys that we think very well may be the culprits, they happen to be odinous, so it's like they had to give her some information on the odinistic aspect of it. They had to. Otherwise, it looks like crazy talk. When she's like, what did they have to do 115 pages of it? Absolutely not. Should they have never put the Richard Allen can't be a single guy theory in there, blow by blow, wringing the pathos out of it, dragging, like just beating everyone over the head that Abby was bleeding out slowly dying. So no, they shouldn't have done that. And my fear, Allison, and I want your opinion on this, is that it could, at the end of the day, because at the end of the day, I just want to clarify with you and for everybody else, the judge can pull out when we do get to the stone cold facts of the Franks hearing. They pull out the things that she says, okay, I find that Liggett did lie about this and this, and I'm pulling it out of the affidavit. Does the affidavit stand? Does it still have enough for it to stand? And remember, probable cause is not beyond a reasonable doubt, kids. It's not even close. It's a much lower burden. So what do you got going on, girl?
It's just whatever. Doesn't matter.
Dude, everyone thinks you're gorgeous. Everybody's saying
I know,
I'm
it's
married
just
up.
like
Relax.
Hair pop out and it's annoying me.
Yeah. So listen.
But no, so Robert,
you understand what I'm saying? But here's what my question is. So say she and it's close. Say that it's close, right, and it's left to her discretion. Do you think that her displeasure with the fact that they filed this, not because of the contents of it, but because they filed it unsealed, that if she's on the fence, she's going to lean towards kicking it down the road, denying the motion and kicking it down the road?
I think it's going to depend on whether they can establish that the omissions would have had some bearing on it. Like that either, I don't think that the fact, like the way Robert Vineyard's question that's up there right now, it doesn't make a difference that this other officers thought Odinus did it, or very, Tooth Fairy did it. That doesn't matter. It's irrelevant. The question is that if the crime scene was described, and that's why I keep making this point about the knife. They went through why we're looking for a gun, but they didn't say why they were looking for a knife, because to me, that's them trying to leave anything out that has to do with the way the bodies were found, the scene itself, that would lead the judge to think that this is clearly, if it's all true, a ritualistic killing. And if there was evidence of that, would she have wanted to see some connection between Richard Allen and that crime scene before she found probable cause? Would that have spoken volumes to her about the perpetrator and wanted to see some connection? If not, then maybe none of that matters. But it's going to come down to whether they can establish either that the fact that there were all these other, suspects that hadn't been, fully fleshed out. I mean, that alone it's not going to do it, and that's why I think it has to be, if she or he, was it a female judge or a male judge, babe?
Gall, female.
Okay. So if she knew, if there were facts in there that gave rise to a ritualistic crime scene and somebody, having an odious tie, that would she have wanted to hear something additional that would have made someone think that Richard Allen was involved or not? Would she have not cared? And kind of that's what it's going to come down to. But a lot of what we're focused on is not necessarily the Franks hearing. It's just the fact that this information exists, and it's like, what, do you have the right guy? And are you ever going to get the right guy? Because you put all your, you've already put it on Richard Allen. So it's more than just the Franks hearing. And from a Franks hearing perspective, some of it might not matter at all, but if the crime scene matters, it might, weigh in the judge's mind that there were all these other suspects and all this evidence that pointed to a ritualistic killing that was so left out of the crime scene that she didn't have a fair picture of the crime to determine whether there was, they needed something more than a guy on the bridge for probable cause for the warrant.
Yeah. I mean, I'm with you there. So, all right. So am I not allowed to swear? I saw a comment on there. So sorry, YouTube. I may have dropped an F-bomb. I'll be better. I won't swear. We've been pretty good. We've been pretty clean for as foul-mouthed as we are in general. But somebody posted that like at the 2-hour mark, we can swear. I don't think we made it. So hopefully they don't demonetize us on our first shot here. I don't know.
If
so I
the
want
judge
to
were to find, because someone else, I saw a question over there, like, well, what happens if they have a Franks hearing and the judge decides I would not have the warrant should have never been issued? Then the evidence that they found, meaning the gun, the gun, right?
Right.
Is tossed out.
They found the unspent casing, and
right.
then they found
So
a weapon that they claim,
right,
that they can somehow they were from an ejected unspent casing that they've been able to use striations and tool markings to say that it was Richard Allen's gun that ejected the bullet, which is
right. So all the evidence found as a result of the search warrant are tossed out. They're inadmissible unless they decide that there was, well, they couldn't decide that there was good faith if they just granted a Franks motion. And then the question becomes, without that evidence, is there enough probable cause to support prosecution? And that'll be a whole nother question. And I don't know enough about their criminal procedure in Indiana to know if that's like the next step, because it seems to me logically that it should be.
Yeah, I agreed. So I want to address because Patricia Burns asked this, saying it's just to taint the jury pool with some reasonable doubt, 100%. So agreed, but doesn't that really just even the playing field, Patricia? Because the way that it usually plays out is the state gets their theory out there, and
right.
we all
everybody thinks he's guilty because of it.
Right.
Anyone thinks he's guilty right now.
That's what I'm saying. Everybody that thinks that Richard Allen is the guy is because they read that PCA, and that's the only thing that existed. There's nothing else. So I didn't really get to like explode your minds because I do get excited and off on tangents occasionally. So here's what I'm going to do. Okay. I want you all for 1 second to just pretend that like everything that Allison was talking about in terms of evidence that we know exists in the police reports. Let's pretend for one moment that instead of Richard Allen being the target of that probable cause affidavit, that they had decided to arrest Elvis and Messer and Westfall and Holder. And what they had in that PCA was that there was a young man who confessed to being at the scene, to spitting on the girls, to leaving his DNA. We have the fact that there's odonistic, I mean, everything that's going to end up coming out at this hearing in terms of evidence, let's pretend that that is what the PCA was. Okay? And that's what the state had put forth. That's how you have to look at this. After we get this hearing and we start to hear everything that was included in the discovery that points to somebody else, pretend for a second that Richard Allen doesn't exist in your brain, and that was the PCA, that they had decided to go that route.
Yeah, everybody would be saying these guys were guilty for sure.
You'd all be saying these guys are guilty. So that's all I just want you to try to, wrap your mind around for a minute, that you're being sold a bill of goods on a flimsy PCA. We have PCAs out there. The Lisk bail application, which had they not got him indicted and they had to go to a preliminary hearing and just get him under arrest, that would have been the probable cause affidavit. That thing, ironclad. That thing is strong.
Are you putting up these questions here? Because I want to put up Jamie's again. Because now she's saying there's ballistic evidence. So I'm going to need you to.
Where's she at?
It's fairly recent, like 7, 8 up.
Oh, from the bottom?
Yeah.
Okay, I'm way behind because I'm trying to catch people's good questions. Okay. There you go.
Do you though?
I mean, Jamie thinks so.
Because Jamie the state told her so.
Right. So, and Jamie, I would just recommend if I had it to pull up, I should have it. Wait, don't you have? Do we like? Was that language that you pulled up from the where they doubled down in the subpoena? Was that from the probable cause affidavit for the arrest? The reason I'm asking it because that's where they put the language from the person that they had do the evaluation, that it was their subjective opinion that law enforcement was not adopting as their own. It literally says that. It was a subjective opinion of the examiner that he believes that the ejected unspent casing matches Richard Allen's weapon. So it's not law enforcement saying that we believe it. They're saying that that guy believes it, and we're going to put him in our affidavit. I'm just going to tell you, Jamie, like if you want to spend a little time Googling tonight, try to find a case in this country where an unspent casing has been used to be the linchpin of convicting somebody of homicide. And you'll be searching all night long because there does not exist such a case. It's junk. Trust me when I'm saying it's junk science. It's not real evidence. It's weak. The strongest evidence that the state has in this case right now is the fact that Richard Allen on a recorded jail line has admitted to killing the girls. That is by far, bar none, the strongest evidence they have. If the defense can put together that these guys wearing the "In Odin We Trust" patches threatened him and said, look, yo, you got one choice here, brother. And that's you're going to tell your wife on a call that you killed these girls, or you know what's going to happen? We're going to kill your wife and your kid. That's what's going to happen. And maybe that's what happens there. Because that's what the state, or that's what the defense is.
Yeah, but we kind of called bullshit on that before.
I didn't call bullshit on it.
Well, on the way the state did it and why they did it.
No, the defense was super slippery.
Defense, sorry. Yeah.
Right. They were super slippery with that. That was like, because when I was reading that first, like on the Twitter spaces, I was losing my mind because they quoted it as if it was like an actual statement.
Yeah. And then when I read the footnote, I initially because I had to reread everything. Like I initially took it to mean at that point in time, they didn't say it because they were still talking about a time when the police were always, or the corrections officers were always around, but they're saying, no, he never said anything like this, but he could have, or.
Yeah. I mean, look, what we know that he did say, which actually, because if you guys don't know what we're talking about, so he makes this, like the defense in the actual memo writes the paragraph as if Richard Allen said that to his lawyers, that look, they threatened, they told me that they were going to kill my wife and my family if I didn't confess to killing the girls. And then there's a teeny little footnote, and then you go to the footnote and it says, now Richard Allen didn't actually say this, but we're assuming that he would have because he said this. And what he did say is that every time that they would come, that he would mumble, is my wife alive? Is my family alive? Is my family okay? Is my wife okay? So he really did say that.
And that Odinists were threatening him or something.
And that Odinists were threatening him. So now, like my problem with that, when I was devil's advocating against that with Allison, and I think we did it in one of our podcast episodes. And by the way, like, if y'all aren't listening to the podcast, I really can't help you. I mean, we're incredibly proud of our podcast. Allison is now co-hosting the docket. If you love what you hear here, she crushes it even more in the docket. And we're doing the deepest dive that'll ever be done on Stephen Avery. Guaranteed. We deep dive, obviously, into Delphi. We deep dive into Idaho 4, a deep dove. I call it a medium dive into Adnan Syed. We're covering the stuff. We're giving you what we know. And again, we don't have to agree on everything. But what we're going to do is only give you facts. I will never speculate to anything. Like Allison would not even let me put up the Tony Click statement that was on Delphi Docs that somebody had typed from what they had heard. She's like, I'm not putting up something that I'm like, but wait, you read it and you said it was exactly what they said. She said, she's like, I'll type it out. So we are just facts here. Like that whole tagline, that's truth. Like more than anybody else. And I know there's other lawyers you can watch out there. But in terms of if you want criminal defense lawyers that have been practicing 20 plus years, and I know Emily D. Baker, she's got a huge following. That woman right there, she's pretty good. She's pretty smart. So this is what you're going to be getting from us for the long term on everything. I mean, if y'all know that I'm on Court TV and so I follow every case as much as I can. It's like my brain's like going a million different places. So it's tough, but what that gives me is the ability to know a lot about a lot of things in terms of these cases that we're all so fascinated about. And what I won't do ever, and what Allison will never do, is we're never going to speculate. We're never going to theorize. We will give you straight
we'll say
facts.
so.
Huh?
We might, but we'll say so.
Oh, yeah. I mean, if we're giving you our opinion, we'll tell you it's our opinion, and we're not saying it as fact.
Right.
Right. I mean, because obviously we're sitting in here talking about some of our opinions, clearly, but we will never present something to you as fact if it is clearly our opinion, and we'll never.
If we haven't checked it and confirmed it's accurate.
Yeah, I'm real big on that. Like if I get called, if somebody throws a receipt at me and like, yo, dude, you screwed that up, I always clear it up. I'm never dying on a hill. If somebody teaches me something, I'm like, hey man, I'm going to go ahead and delete that tweet. And I'm going to go ahead and consider that knowledge learned. Thank you. Not I'm dying on a hill with some bullshit that I'm trying to push out to people who are then going to go and repeat what I've said. It's not what we're about ever. So that you can trust. You can take that to the bank. We will give that to you every single time we are streaming. And we happen to know quite a bit about criminal law and the judicial system and the process. Oh, so Travis, I threw this up. Illinois, no, man, we do not get depositions in criminal cases, which is
unless
kill.
the person is like, like you have reason to believe they might die or they're
Right.
going to somehow be unavailable. And back when we had the death penalty, you could do it in death penalty cases.
Exactly. So no, but is general course, no, absolutely not. So they're super lucky.
Not in criminal cases anyway.
Right,
Civil,
not
yeah.
right. Obviously, civil, you can depose everybody, and in divorce too. But so for criminal, no. In Omaha, we could depose. Like we got to depose expert witnesses. We could depose fact witnesses if we wanted to. So to me, it's preferable. Like, why shouldn't we be able to talk to witnesses? Because here's the reality of the life of a criminal defense attorney. The state, they get their witnesses, they put out that PCA like everybody does. Oh, they got the guy. And sometimes, you know what? They get the guy. I'd say more often than not, they have the right guy. Occasionally, they don't have the right guy. But like what happens is when they talk to these witnesses and then we send our private investigator out to go try to talk to a witness, they then run, they say, hey, you know what? Hold on for 1 second. They run inside the house. They click their cell phone open. They call the state's attorney and say, hey, the MATA's got their private investigator out here and they're asking me if I'll talk to him. Now, the state's attorney cannot say, no, you cannot talk to them. What they can say is, hey, you can absolutely tell them no. You have no obligation to talk to them.
Like, if you don't want to talk to them, send them out of there right now. Tell them to turn around and go away. You added an if there. If you don't want to talk to them.
Right. And that's typically exactly what happens. So typically when you're watching defense attorneys at trial, test or cross-examining witnesses that the state puts on in their case in chief, that is based strictly on a police report. And that's it. Or a recorded interview. And that's it. Like we don't have the like fairness seems to me would be where we could go and depose these witnesses ahead of time under oath so that if they get on the stand and they lie or say something different, we can impeach them with their prior testimony. Why should we not be able to ask questions? I mean, it's the search for the truth, but that's a whole different stream, which I'm not going to get into now.
Did you just touch on this, Jennifer Griffin's question, or you never really got? Oh, I think you just said, go see that there's never been a case where about how you can't really identify a weapon from an unspent casing.
Oh, you mean Jamie's? I think I did.
No. There was the follow-up question by Jennifer Griffin was, would it be possible to identify my gun magazine strictly if I cycled around through it? Obviously, it wouldn't have rifling or other marks because it hasn't been fired.
Right. And the answer is no. Not with, I mean, they couldn't say it with any kind of reasonable degree of scientific certainty.
And tell them why about the difference between guns before and now.
Right. So back in the old days, they used to hand make weapons, which, I mean, everything was handmade. The barrels were handmade. So any kind of defects in a barrel when it's being handmade is going to be specific to that barrel. They're all machine made now. I mean, if you've got somebody that's got like an early aged gun, like a late model gun that was not made in a factory in a machine press, like that, they could probably run ballistics on, because then you do have defects. They're going to be incredibly particular to that weapon, much like our fingerprints, and they will be able to match. They'll fire bullets through, and every bullet should have the exact same striations and tool markings, but like now that's just not the case with modern weaponry. Like modern guns are all made in a factory. And does that mean that there can't be a defect? Of course not. Yes, there can be, but for the most part, it's just like we're on the verge. And much like, so the law and evidence is always evolving. Like when you think back, like when Ted Bundy got convicted, they convicted him on on bite mark analysis, saying, oh yeah, that is completely rejected as junk science now. Hair comparisons. Can you imagine like being held at, like you're being held in a jail awaiting trial, and they're going to try to convict you on saying that a hair that they found at the scene of the crime and a hair that they pulled out of your skull, that they look like the same hair. They matched. They actually used to do that. So that kind of stuff has gone away. Now we have progressed to the point where we have DNA, but DNA's got its problems too. DNA, as we're starting to learn, as the general public is starting to learn, is very easily transferred. There's cases out there that are shocking to the conscience where, like DNA was transferred by a paramedic to a victim in a case from somebody that he had treated earlier that day. That guy that he treated earlier that day, who the paramedic actually transferred the DNA from that guy to the victim, was arrested and tried. I mean, everything's got its flaws. There's nothing that's 100% fallible, and it's just like when we get a case like this, and again, I'm not trying to sit here and stump for Richard Allen because I'm a Richard Allen fan. I'm trying to say that there exists evidence which we are now privy to, which we're typically not prior to trial, that is requiring, I think, law enforcement or I'm kind of over Indiana State Police and Carroll County Sheriff and whoever else they had a part of it. I'd like the feds to step in and take a peek, because I think we owe it to the girls to do that. Because if anybody on here saying I'm not going to look at anybody other than Richard Allen and you're basing that on the PCA, I can't help you. And I'm not going to try to convince you, but like, that's just not how the law works. I mean, nothing can be trusted until it's vetted at trial. I say it in every episode of my podcast. We don't know anything about this evidence until it's vetted for trial. And that goes both ways. That goes for the defense and it goes for the state. Until things get vetted at trial, we can't trust it.
And someone asked a question of, do you have issues with like all ballistics evidence or just on an unspent casing? And the answer to that is there have been recent studies, and it goes all to this whole mass producing thing, I believe, but there have been a lot of recent studies, I think starting like 2020, that ballistic evidence is significantly flawed and should no longer be allowed, and that the courts need to reassess whether or not it's reliable evidence. So it depends. I mean, I think there are, there's definitely issues with ballistics, what's called ballistics evidence or tool marking evidence, however you want to term it, overall in general, but most assuredly on an unspent casing.
Yeah, I mean, I'm just with you. And look, here's the reality, though, is that when you get 12 jurors in a box and you get the state with their guy who's going to say he thinks that it came from there, and then you're going to get the defense expert who's going to say it's junk science, those two guys are going to X each other out. And when you get 12 jurors, what makes it scary from the defense perspective is that when 12 jurors, even if they're not buying what either expert is saying, when they have a bullet and it's been suggested that it matches Richard Allen's gun, it becomes a scary and powerful piece of evidence, just in reality. So it's like, that's why they want to get it suppressed.
That's why it's so important that the judge be the gatekeeper and reconsider this stuff, because if it's left to, we'll let the juries weigh it and let them decide. When the state puts in evidence, jurors are inclined to believe it. And that's why Bob talks about a lot, like, voir dire is so important. Like, I hammer home to people, like, are you just going to believe it because the state tells it to you? Are you going to be able to sit there when 11 other people say guilty? If you believe not guilty, are you going to be able to stand your ground? And vice versa. If everyone's saying not guilty and you believe guilty, are you going to be able to stand your ground? And are you going to be able to challenge the evidence? And are you going to be able to look at, because to get those thoughts in their minds right off, like, wait a minute, should I not accept everything that the police tell me just because the police told me? And should I not accept everything the state says as true? And I think in recent years, no matter what side of the aisle you're on, or like whatever your political beliefs are, everyone is seeing that you cannot trust the government in all different aspects when it comes to trials and when it comes to, charges and when it comes to charging documents or grand juries, whatever the case may be. And that's helpful to, defense attorneys now.
Yeah. And I mean, look, that is not to say that they don't get it right a lot of the time, because a lot of time they do. A lot of time they have smoking gun evidence. A lot of time criminals are idiots. A lot of time, but those cases typically you don't go to trial. Like that, it seems to be like kind of a thing that people don't get, is that 90% of cases plead out. That's the reality. Like 90% of the time, the cops do a good job. They get the evidence, or the criminal was an idiot, or all of it involved. And you're saying, you're going to your guy and say, look, man, they got you kind of red-handed. I mean, we'll obviously do the motion work. We'll try to get things suppressed if we can. If they violated his constitutional rights, we'll, of course, always protect the Constitution. But, I mean, most of the times things plead out, because of the strength of the evidence, because of a good investigation. That does not mean that they don't screw it up sometimes. That does not mean that they do not develop tunnel vision sometimes and focus on just the wrong individual to the exclusion of everyone else. Because it happens. I mean, how many wrongful convictions do you have to see to know that it happens? I mean,
Right.
I like anybody who tells me like everybody who's so sold on a PCA just frankly makes my skin crawl. Like I don't know any other way to put it. Like it's like so close-minded that you're just believing a piece of paper. It's like that was what got me on Coffin Daffer. Like her, like
Can we not
whatever.
talk about her? So,
Like-
Life After Life, Paranormal and True Crime. Did you read her comment yet that you put up there? Bob and Allie, what are your thoughts on RA confessing to his wife? Was this hear, say, or do they actually have a recording of this? So I'm assuming they do have an actual recording of it. And what Bob and I were
I
saying,
can confirm that.
Even before this memo, was we need to hear it in context. We need to hear what he was saying, how he was saying it. Was this a guy who's just like fed up? Was this a guy like, did I do this and I don't remember? Like without hearing it in context, I was like, I am not even considering it that he confessed. That was my opinion. I'm like, as far as I'm concerned, no confession until I hear this. And now, given the evidence of like that he was telling his lawyers before that he was being threatened by Odinists and that they were like never leaving him alone, and he was asking questions like, is my wife alive? Is my family alive? And whether or not he was having these emotional or mental health issues at the time. Was he speaking coherently? Was he speaking quickly? I mean, to me, until I hear it, I am like, it's not even a thought in my mind that he confessed. I'm like, no, he didn't confess until I hear it.
Right. And look, I mean, there's an X factor now. Like we cannot I'm not going to pretend that these Odin dudes, like it's beyond a coincidence. It just is. Like like, what do you mean? Like, what are they?
I mean,
what
I
are you
just
talking
don't.
about.
This is the part I don't buy. Okay.
Oh God, you're nuts.
If let's say that these guys who were Odinists
in rural Indiana,
and every other Odinist knows it, I just think it just so happens. I don't know. It does seem like a very strange coincidence, but it could be. It could be. It just so happens these guys like that are in charge of overseeing him primarily are Odinists, and there happened to be an Odinist link, or maybe they all know. I mean, it is very, very coincidental. I just can't believe that the guards are in cahoots with the murderers. That's the part that I like.
They don't have to be in cahoots. It's merely they're protecting people that are of their own like faith. And again, this really boils down to white supremacy. Like Rick Ross was like, oh, show me the leader. Where's the church and all that shit. And I'm like, well, like you're acting like there has to be organized like that. You can get a crew of knuckleheads, racists in like rural Indiana that are gathering under cover of darkness for the most part, in whatever their secret club is of hate. And, and they're all kind of like into this whole Viking thing because Vikings are super cool. You know what I mean? I wanted to be a Viking when I was watching. I was like, man, why couldn't I have been a Viking? It seems like it was and I'm saying it kind of jokingly, but I meant it. Like I was watching, I was like, man, I love the concept of Valhalla, and I love the way they said it, but it's like I just do not think it's that far afield, Allison. I just
I mean,
don't. I just don't. To me,
yeah, if it has gotten around and like other people know this was odenistic, then for sure there's like they could be trying to make sure that that never comes out. And
all right, so here's the thing I want to ask you. What can the defense do in terms of trying to get subpoenas for these guys' phone records based on the fact that they are putting them forward as alternate third suspects or alternate suspects?
So I searched the law in one of our murder cases for like, how the hell can the defense, apply for a warrant, essentially force the police? And I did it in that case, and I just filed a motion telling the judge that this evidence that in that case they had picked up found a cell phone, an iPhone at the scene, and they never ran an extraction of it. They didn't do any Cellubrite. They didn't do anything. And I forced them to do it. And then the judge told the police that they told the prosecution, have the police request a search warrant. So, I would have to look at Indiana law, but I really think part of like the reform of the criminal justice system needs to allow the defense, their private investigators, to apply for search warrants, to do all of that stuff. So they should be able to put the same evidence that's in that memo, which would be enough if the police put it in there and requested a search warrant and request a search warrant. And then they would have to, compel the
well, why can't they use subpoena power of the court? Like,
well, they can't use subpoena power to get data, like their actual texts, because that you need a search warrant for. You can't just you could use the subpoena power, but you would need a judge finding that there is probable cause I
thought for Garcia, they just used initially that they used subpoenas for his bank records and phone records.
Yes. Phone records that deal with phone calls to and from. Yes.
But not text messages.
Right. If they want the actual words spoken, they need a search warrant finding probable cause because that involves a higher level of privacy right.
Right.
So, but in theory, the defense should be able to, I was thinking about this, and I think that because I know we originally looked at the Indiana statute, and that it's like in order for him to be bailable, because right here there was going to be like a huge bail hearing that never happened, or was that in another case? I can't remember anymore.
Yeah, it was supposed to be this one.
Right. So they could have put all of this evidence would have been extremely relevant to whether or not there's strong evidence of guilt.
But they didn't know it. Like they weren't even close to having this information at the time that they filed that.
But they never proceeded on it. They could have refiled that, put all of this information in that motion, and it would have been all of it relevant.
Totally relevant.
Whether there is significant evidence of guilt, because that is the question when you're dealing on a capital case with whether they can be released. Is there significant evidence of guilt? And there is none here. So I don't know why they chose the Frank's route to throw all of this at. And maybe there's something I'm not thinking about right now that, is relevant to this that I'm, but it would have been, much more directly relevant.
All right, so Law Nerd Amber, who's Jennifer K? Who are you trying to hook us up with? Put it in the chat. Like I'm not seeing a Jennifer K anywhere here in this chat. I don't know.
And I do just want to say, because I know we're probably getting close to the end, because
we are getting close to the end. This is true.
That again, whether to us, Bob and I, whether or not, even if the judge denies even going to a Frank's hearing or denies the motion after going to hearing, I mean, that's not like what we're throwing our arms about. We're throwing our arms about this information is important to justice and to getting the right person. And, and so it's not like we're saying they need a Frank's hearing and they should win a Frank's hearing. not that we're not saying that, but the point is just more like there is this whole other world of information that points in a different direction that needs to be fully fleshed out so that they know whether they have the right person.
All right. So if any of my mods are in there, throw our link on there, please. Again, I haven't seen it in ages. It should be in there every 5 minutes, frankly. If you guys are not following us on here, please subscribe. If you're not listening to the podcast, I'm very, very disappointed in you. I mean, like, it's just a really good podcast. Like, I don't know. Like, don't even trust me. Just go read the Apple reviews. Like, they're all real. Like, there's 1,200 of them. It's a 4.9. It's like,
they know we're awesome. They get it. They get it.
Well,
one thing I'm going to say is this:
there's still people in Jay's stream that are not listening to like as many times as I've been on there. There's maybe
should we hunt them down to their homes? Maybe we should.
I mean, I kind of feel like I need to, maybe. But
well, I want to just one more comment, and then I'm going to stop. Travis Williams, Esquire, talking about.
I like Travis. Travis has been kicking the knowledge tonight.
You know, like basically using the subpoena power, like you mentioned. They could use the subpoena power to get just phone calls, text, not the messages, but the fact that a text was sent and a phone call was made to and from this number that on the dates around the crime and at least have some basis there to say, now we need the actual data because they were all communicating back and forth, you know, but maybe they wouldn't be if they were all together or the minutes before, who knows? I don't know. There might be something there in the regular phone records that don't have actual content or not content based, which would require a search warrant that would provide additional basis for a search warrant. All
right. Yep. All right. Jamie's asked a lot of good questions. Like, so she was asking, like, if there's some, like, if the kid did spit on one of the girls, you know, I mean, the problem is at this point,
the defense would have pointed that out, right? That there was
unknown. Yeah, but if the evidence was, if they didn't get swabs off the girl, like if they weren't looking for saliva on the girl, you know what I mean? It's like, there's just so much here that like scares the hell out of me about this case. And it starts with just the incredibly shoddy investigation. The fact that they buried Richard Allen's voluntary statement for 5 years, buried it, should tell you all you need to know about this investigation. Period. All right. So look, y'all, you guys are amazing, man. We were 300 plus strong here for our first real stream. We went long.
I wouldn't listen to us for 2.5 hours.
I mean, like Allison, like if she was sitting next to me, she'd be kicking me in my leg, being like, "Come on, let's end it. I'm hungry. I want to watch. What is that show you're watching?
No, stop.
Vanderpump Rules, whatever.
No, that is ridiculous. Now stop.
Hey man, that's we're not allowed to have like our, what do they call that? Our guilty.
Oh my goodness, that is
guilty pleasures. Guilty pleasures.
That's not even accurate. Stop.
Wait, are you gonna sit here and lie on a live show?
No, there's a whole backstory to how that even happened.
Oh yeah, so like Allie was told, and she's always good for like a scandal, and it was actually told her it was a conspiracy. She's like, in the history, well, you thought in your mind it was a conspiracy.
Right. Ended up being scandal.
Like she had a couple of friends and our oldest daughter, who's 29. She's
but a very trustworthy friend say it was the biggest scandal in TV history, which I, for whatever reason, kept thinking conspiracy until I went back and read it at the end when I was like, where the fuck is this? Sorry.
We can't swear. We just got demonetized. Oh my God. Oh, it was good while it lasted. And I don't even think I like put any of the stuff up for people to subscribe and like super chats and all that stuff. It was good while it lasted.
But let me finish because no, you set me up for this, so now I have to tell them even though no one cares.
Oh, all right.
I have been rowing, and I row like our water rower in front of the TV. So I'm like, I need to find something that Bob's not like that. Bob and I don't watch together. So I text my friend and our daughter. All right, reality TV people, tell me what to watch, and I will do it. And that's how that happened.
And she buzzed through 10 seasons like a complete.
To try and get to this conspiracy scandal.
If Vanderpump Rules or whatever it's called was cracked, she was hitting that pipe hard.
Well, I was fast forwarding a lot of it too, though. All right, no one
It
wants
was
to hear
something.
this
All
nonsense
right,
anymore.
y'all, we love you so much. I hope y'all were smashing the like button. It seems like y'all weren't throwing our stuff in the links enough. Like I'm
No,
like,
they were doing an amazing job. There's 253 likes. We love you, Shannon, Jay, and whoever else is doing
I
that back
love
there.
it. Was
And
Stevie.
all of you.
Stevie, I'm talking about publicly buzzed. Stevie is
Oh.
amazing. We love him so much. And we love you all. Thank you guys so much for hanging with us. Check back Wednesday. We'll be doing another
And don't
live.
forget to watch Publicly Buzzed and The Shaming of Jay, especially because Bob is often
Yes.
on it, but also because they are amazing in and of themselves.
And between the three shows, we are forming a wonderful community of beautiful people that are just salt of the earth, that are all incredible. And like everybody's smart as hell. Like you could look at, like, you read through these chats, and man, like people coming with the questions, like legit questions that are great. So like it makes it fun for us. I mean, you guys, without y'all, I'd just be an old man and a gorgeous babe talking about some law cases, man. That's it.
All
So
right.
we love you guys. I have not come up
Bye.
with a good like tagline or sign out line like Jay has, but I will guarantee it. So we love y'all. Just facts, baby. Just facts. Peace.